Hi, my name is Deb Dumontier. I'm the Deputy Special Trustee with the Office of Special Trustee for American Indians with the Department of Interior. I'm also a licensed attorney with the state of Montana. And I want to welcome you and thank you for being part of this continuing legal education. It's a very important topic, and we're going to be providing today just an overview of the Indian will drafting and the Indian estate planning. There will be very talented and expert individuals following me. They're going to go more in depth into many of the things that we're talking today. But part of what I wanted to do today was really just provide an overview of the federal Indian law policy, the fiduciary role of the federal government, the federal administrative process, the trust reform that we've been experiencing, the legislation that has been passed to try to address some of the fractionization and recognition of some of the issues that basically federal policy in the past have created. The Indian Land Consolidation Act and amendments, the American Indian Probate Reform Act, which basically is what this CLE is going to be covering in depth. And also just touch a little bit on the Cobell settlement and the land buyback program. So this is a map of Montana, and you'll see there is 7 federally recognized reservations in Montana. There's 1 state recognized, but you can see all the Aboriginal territory and all the Indian influence within the state of Montana. When I was part of the Equal Justice Task Force, one of the things that we looked at was the legal needs, and the legal needs that was identified in Montana was Indian will drafting. We want to make sure that our Indian landowners are aware of the options that are available to them so that they can be informed decision makers. We want the opportunity to empower our clients with the distribution of wealth. And really just to press upon the attorneys who are here, as well as the students who may be watching this, that this is a very interesting and it's a very complex area of the law, but it certainly is an area that there is a need, and it can be very rewarding, a very rewarding experience. Part of the overview of the federal Indian policy is looking at the different eras of time where federal law or policy has interacted with tribal relations. And we start with treaty making from the very beginning when the federal government had the policy to negotiate with tribes, tribes retroceded lands. Then we moved to an era of time where there was removal of tribes and individuals onto the reservations, so they moved from the East Coast kind of to the West. The allotment and assimilation era. And we're going to talk more about this because this is actually the period of time that created individual land ownership. And it's something that the federal government has been looking at and individuals have been dealing with, and it's had negative impacts as to economic development and jurisdiction, etc. The reorganization time, the Indian reorganization, termination and relocation of tribes, and then self-determination. And that's just a real broad overview of the policies. And this particular slide is kind of difficult to see, but it's the Klamath Tribes Historical Trauma wheel. And why did I provide it? I think it's important to understand from a tribal perspective and maybe an individual perspective how federal policy has affected them, because you're going to be working with individuals who may be familiar with their tribe and their stories. And so sometimes it's very helpful to understand that from creation, and this particular wheel represents over 1,200,000 years ago, where tribes did not have influence with non-natives, and then you see that influence starting with non-natives, wars, termination, re-recognition of the tribe, to a resilience and a culture to where the land is restored to the tribe, and how significant that is. So when we look at culture and diversity and the complexity, and that's the interesting part about this particular field of Indian law, is it's very interesting and it can be complex. But when we look at myth or facts, there are federally recognized tribes in every state except Hawaii. No. There are 567 federally recognized tribes, 337 in the lower 48 states, and 230 Alaska Natives entities. And there are 17 states, including Hawaii, that do not have federally recognized tribes. What is the Federal Indian Trust responsibility? This is a complex area, and there's really not an easy definition. We don't have a specific trust document. We have statutes, we have treaties, we have executive orders, and we have court decisions. And I've provided an additional handout that provides some of the case decisions as well as some of the statutes. But we're going to be concentrating on, so what is the Federal Indian Trust responsibility? Over case law, we have seen this be established under where the United States has charged itself with a moral obligation of the highest responsibility and trust towards Indian tribes in the Seminole Nation case. But it started even much earlier that with the Marshall Trilogy cases, in which the Supreme Court found that there was this trust obligation in Cherokee versus Nation, Cherokee versus Georgia. And over the years, this particular trust doctrine has been the center of numerous Supreme Court cases, and it is one of the most important principles in federal Indian law. Allotment and assimilation is something that happened over 100 years ago, and it's important to recognize that we went from communal land owning to individual, and there were allotments that were given to 40, 80, 160 acres, and they were given to individual Indians with the thought that they would assimilate and become part of the community. They would be held in trust for 25 years, and there was no taxation for that 25-year period. But what we found is that the tribal land was split up and given to tribal members. There were 219 reservations that were allotted during the period of time of 1887 to 1934. And the owner remained the United States federal government, and it was held in trust for individual beneficiary Indians. After the allotments, the lands were opened up to homesteaders, and there were 46 reservations that were open to non-Indian homesteading. And over 90 million acres of land was taken out of tribal ownership. And that substantially reduced the tribal land holdings from 139 million acres to 48 million acres by 1934. And then individuals who had these allotments, state law applied, and heirs would take land as tenants in common, and that's what we call the fractionation, and it soon became a very serious problem. The Burke Act of 1906, it allowed the Secretary of Interior to issue fee patents to allottees. And so we had 60% of allotments that were lost. The trust status was lost into fee. And again, we had about 900,000 acres, or 90,000 acres that passed from tribal ownership. The Indian Organization Act is a period of time where we saw a real shift of Indian law policy from allotment and assimilation to recognition and promotion of the self-government and economic development. It stopped allotments for a period of time, extended the trust period. The surplus lands were provided back to tribal ownership, and it authorized the Secretary of Interior to take land back into trust. It established tribal governments. And the Confederated Salish Kootenai tribes north of here from Missoula, they were the first to adopt a constitution under the Indian Organization Act. The IRA really was the official turning point for the federal government to be trustee over Indian lands. The IRA sought to prohibit, devise, or allotment of trust allotments unless there was approval, except for to tribes, Indian persons, or heirs. Part of the problem, direct loss of land, we see a checkerboard of ownership of jurisdictional issues, inheritance pursuant to state law, the fractionation. The Montana State University has a fact sheet on their website that goes through a little more fractionization, and so will the folks who are following me. Are going to discuss this concept. Also, there was no authorization for individuals to even have a will until 1910, so we saw allotments that they just continued to fractionate with no ability to consolidate those interests. The Indian Organization Act also prohibited allotments from being sold, leased, or mortgaged without the consent of the Secretary. So oftentimes, as land continued to fractionate, it made it very difficult for individuals to do anything with their property or to see the economic development from that property. This is the Flathead Indian Reservation, 1855. This is federal Indian law and policy pursuant to their maps. So we see a grant of the treaty, and you can see here the state of Montana, and here's Flathead. You can see the Flathead was not allotted by the Dawes Act. There were other legislation that allotted some of the reservations, and CSKT was allotted by the Flathead Allotment Act of 1904, and the orange represents the allotments that were given at that time. There were 3,380 allotments issued to tribal members. Then it was open to homestead, and you can see the tan where it's open to homestead, where individuals came in and they were able to claim lands. There are also school property state sections. The gray part are the state sections, and also the creation of the National Bison Range. There was a second round of allotments as well. That's not uncommon to reservations. This particular reservation, the second round of allotments, there was a reservation to the tribe for timber, but there were over 400,000 acres that were patented to homesteaders, 61,000 to the state, 18,500 acres to the National Bison Range, and basically the tribe owned less than 40% of the reservation. After the passage of the Indian Reorganization Act, the tribe started purchasing back their lands, and they are continuing to do that. But this is federal Indian law and policy, like I say, visually by the map. So Congress recognized that there was a problem, but it took some time before we saw legislation that was trying to counteract fractionalization. And the first attempt was the Indian Land Consolidation Act in 1983, and it was amended in 1984. And it didn't have a federal probate code at that time, but it did have some self-executing rules. They were basically deemed unconstitutional. That was the UP case and the Irving case. It was amended, the Indian Land Consolidation Act amendments in 2000. It created a pilot project for tribes to purchase back interests. Very few tribes participated in that program. However, CSKT, they were one of the tribes that did participate. The Indian Land Consolidation Act was passed to prevent further fractionalization of trust allotments and to consolidate fractional interests. It was to promote tribal self-sufficiency and self-determination and basically reverse the allotment policy for Indian tribes. And this is the first time in 2000 where we see the Dawes Act actually repealing the authorization of allotments. The Indian Land Consolidation Act was kind of the precursor and the non-probate provisions. We also see the American Indian Probate Reform Act of 2004, and we're going to hear a lot more from that from Judge Waits. It addressed many of the objections that were raised by Indian country. It created a federal probate code. Again, it had the APRA has the same intent to limit fractionalization, prevent loss of trust of land, promote land consolidation, and also there were some owner management provisions in the law. So what is the Department of Interior's fiduciary role? We talked about the federal government having a fiduciary role. The Indian Trust encompasses about 56 million acres of land, about 56 million of subsurface mineral estates. About 10 million of these acres belong to individual Indians. About 46 million is held in trust for tribes. Interior also has the responsibility to manage the trust funds that are generated from these lands. The Office of Special Trustee, the office where I work, manages about 400,000 individual Indian monies accounts, about 3,000 accounts for tribes, for more than 250 federally recognized tribes. These funds come from the land, the timber, the oil, the gas, and the mineral resources. The federal trust responsibility is held by a number of bureaus and agencies within the federal government. Here's an organizational chart for the Department of Interior. You'll see the secretary, currently Secretary Sally Jewell, the deputy secretary, but all of these programs, pursuant to the reaffirmation of trust by secretarial order, was recognized as having a trust responsibility. And you'll see the office that I work for is in the Office of the Secretary, Office of the Special Trustee. The American Indian Trust Fund Reform Act established the Office of the Special Trustee. This was in response to tribes and individuals wanting improved management and accountability of the Indian trust funds held by the Department of Interior. OST manages the financial trust assets for both tribes and individuals, and the role of OST in trust reform has really been evolving. We had re-engineering of Indian trust, the systems. We had an as-is project to really understand the way the trust processes were being administered to the 2B to try to improve and streamline those processes. With trust reform, with the accomplishments, we have new systems. We have the Trust Asset and Account Management System. You're going to learn a little more about that system as well. But that's for the title and leasing, and it's universal. So it's not just individually held at different agencies now. It's a universal system. So no matter where the individual owns their trust property, it would be that information is accessible through the TAM system for the owner. The Trust Fund Account System, TFAS, that's an OST system, and that's the management. for the IIM accounts and tribal accounts. And these systems integrate that allow us to provide statements to individuals so that they know what they own. So the Bureau of Indian Affairs manages the land and natural resources. OST manages the financial resources, and you're going to learn more about what OST does from some of our fiduciary trust officers. The Confederated Salish and Kootenai tribes, pursuant to self-governance, they perform many of these federal functions, and you're going to hear from one of their staff as well as to how they perform that function. The Office of Hearings and Appeals, OHA, they're responsible for adjudicating the probate of Indian trust assets. So part of trust reform was to develop a fiduciary trust model. Automated systems, risk management, policies and procedures, records management, training, workforce planning, and fiduciary security and internal controls. And you'll see all the different functions, but in the middle is the resource and the individual's beneficiaries. Some of the trust reform systems, some of our acronyms, and you're going to learn more about those today as well. Our Trust Beneficiary Call Center, we call it the TBCC. It's located in Albuquerque and was part of the Comprehensive Trust Management Plan. And it was an attempt to provide a one-stop shop for individuals to call about their trust assets. They have been in place since 2004. They have logged over 1.7 million calls, and their average first-line resolution rate is about 97 to 98%. We also have calls that are referred to the field for further resolution if they're unable to answer those questions. So what are some of the examples the beneficiary may have? They can call the TBCC, ask about the balance of their account, they can request funds, they can ask about a lease. The TBCC has access to all those trust systems to assist the beneficiary, and it's a real trust improvement. The record keeping, of course, the record keeping is extremely important, and the trust records. The records are essential to that trustee-beneficiary relationship. We have the American Indian Records Repository. That particular facility is located in Lenexa, Kansas. It was part of trust reform as well. We've collected and indexed over 300,000 boxes of inactive records from various records facilities, BIA storage, and other locations. These records are accessible through a process in which you can request them from the air, and they have a one-day turnaround. And this is just a picture of it's basically a cave, literally, and it's an economical way to be able to store records. The climate is always controlled, and we have an office there, and that they're indexing records, and they're stored in boxes. We're trying to modernize this process as well by digitizing records, and that'll be something that we'll be continuing to work on as part of our trust reform improvement. One of the reasons that we have seen attention to trust reform and funding for those initiatives is that the federal government was sued. We call it the Cobell lawsuit. And here is a picture of the late Eloise Cobell with President Barack Obama. That particular lawsuit was settled in 2009. It was a $3.4 billion settlement. Part of that settlement, $1.9 billion, was set aside to purchase fractionated interest from willing sellers at fair market value, and there's a 10-year time period. The land buyback program has been purchasing interest. They've been in Montana at a few of the reservations, and will be continuing that program throughout the nation for the eligible tribes, and purchasing interests that were held from individuals in trust, and that will be turned over or basically put into the title of the tribe with jurisdiction of that land. There's a lot of information about land buyback. They've been doing a great job. They have a status report for more information, and I have those websites. So here's another map of Montana and the ownership by color, and you can see the reservations in the maroon. One reason why I'm starting to conclude with this map is so that you can see all the remote areas that we have. We have a lot of distance between those areas, and the Department of Interior no longer provides will drafting services. So the Department of Interior, through the Office of Special Trustee, we have been collaborating with law schools, with associations like the Montana AAA, Legal Services, to provide estate planning to individuals. Oftentimes we can provide landowners with the information, but it's very important that we have the legal resource as well, attorneys that can assist them with drafting their wills. Right now, as I said before, If an individual should pass away with interest in trust, there must be a probate. There are opportunities for us to be able to inform the Indian landowner so that they know what their options are. Could be land buyback, could be estate planning, could be gift deeding, and those are some of the things that you're going to learn about today as well. So why is Indian estate planning important? It's our opportunity to educate, inform, and assist Indian landowners, to help them understand the process and the terms, to assist them to facilitate transfers of their trust interests to their heirs or devisees. It's also an opportunity to discuss the potential impacts of APRA. You will learn the American Indian Probate Reform Act. It's a federal probate code, and it does have tools that are there to attempt to limit the fractionalization of interest. So it's very important that individuals have an opportunity to have a will, to have an increased use of the wills, and also an opportunity to reduce the complexity and the quantity of Indian estates that pass intestate through the probate process. And there are some other tools that we can use if the landowner is informed, if they're eligible for land buyback, that's one. There's gift deeding as well as will drafting. These are some helpful websites. The Office of Special Trustee has some information. The Land Buyback Program, as I referred to earlier, they have their status report there. The Bureau of Indian Affairs, and again, our Trust Beneficiary Call Center. And it's open six days a week and toll-free, and they're there to answer questions for our beneficiaries. So I want to thank you for this opportunity to present and to start this very important conversation. The overview, I know, was very high level, and I think it's very important that we have the opportunity to understand that wills are very powerful documents. They must be updated. We need resources for our individual landowners to be able to go to seek the legal assistance that they need. So I want to thank you for your attention and your time today.